Welcome back. The second session of our symposium is Indigenous Peoples and Apex Court. The panel is going to explore both the challenges and opportunities of an Apex Court with Indigenous laws and reconciliation. We have renowned panelists who will be introduced by our moderator, mais moi j'ai l'honneur de vous présenter le modérateur de la session.
Of the session, the Honourable Justice Sébastien Grammond.
Advocate who stood on that side of this podium many times, and now Justice of the Federal Court. Over to you, Juge Grammond.
Thank you so much, and welcome to the second panel of the day. We will focus on New Zealand and Canada as we have speakers from both countries, and let me introduce them to you. First, Joe Williams is a judge of the Supreme Court of New Zealand. He was the first Maori to be appointed to the Supreme Court in 2019, and before that he had a long judicial career. He led the Maori Land Court and then the Waitangi Tribunal. And then he became a member of the High Court and then the Court of Appeal. And we're proud to underline that he has an LLM from the University of British Columbia. Maintenant, Naiomi Metallic est Micmac de la...
Naiomi Metallic is Micmac from the Lisbuk community. She began her career here as a law clerk to Justice Bastarache. She now teaches at Dalhousie University, where she holds a chair in Aboriginal law and policy.
She worked in private practice for several years, mainly representing Indigenous communities, and she still does so on a part-time basis. She recently delivered a brilliant argument here in favor of Indigenous jurisdiction, and perhaps that's why she was recently appointed King's Counsel. So there are three themes that stand out when we consider the role of apex courts regarding Indigenous peoples. First is the impact of the justice system on Indigenous peoples. Second, the question of how can an apex court create space for Indigenous law? And third, what's the relationship between apex courts and Parliament and the executive when Indigenous rights are involved? So we'll have a conversation on each of these three themes this morning, and we'll reserve a few minutes for questions at the end. You can use the online tool. Alors, nous allons commencer avec le premier thème.
We're going to start with the impact of the justice system. We know that Indigenous peoples are overrepresented in the criminal justice system, in prisons, and the youth protection system. So, I have a question for Naiomi. What was the Supreme Court of Canada done to reduce these impacts? Was it effective? Does it change the behavior of the actors in the system? First of all, thank you very much for having invited me here today. I'm very happy to be here. And thank you to the Justice and for the Supreme Court for having invited me here today. So, with regard to your question, I would say that in the criminal justice system, the measure that's most important is the interpretation that the court gave to a section of the criminal code that imposes, which requires judges when sentencing Indigenous offender to consider any alternative sanctions that are reasonable in the circumstances. In the Gladue decision, the court stated that although this provision cannot resolve all the problems faced by Indigenous people in the criminal justice system, it allows sentencing judges to play some role in redressing injustices by requiring them to consider the unique, systemic, or historical factors that may have played a role in bringing the Indigenous offender before the courts. But in the years that followed, the adherence of trial judges to the Gladue decision varied widely. In 2012, the court was forced to issue a decision to reaffirm its position in the Gladue case in the Ipili case. In doing so, the court recognized that the Gladue decision had not had a discernible impact on reducing overrepresentation, and that this appeared to be partly attributable to a fundamental misapplication of the Gladue decision by some trial judges. The court clarified the approach and emphasized the important role that sentencing judges can play in fulfilling the promise of Section 7182 to reduce the overrepresentation of Indigenous peoples. Has it been effective? Well, since Ipili, the overrepresentation has not decreased, particularly for Indigenous women, who represent 50% of all federally incarcerated women. Moreover, the ability of Indigenous offenders to obtain Gladue reports remain highly uneven across the country. So Gladue and Ipili have not been the panacea for overrepresentation, but that was never the intention. It does show that more needs to be done. In this regard, a less cited part of the Gladue decision is the directive given by the court to sentencing judges to consider appropriate procedures and sanctions in light of the Indigenous origin of the accused. As some jurists have pointed out, this is an invitation to take Indigenous legal orders into account. So far, however, this part of the Gladue judgment has received less attention. In the case of the overrepresentation of Indigenous children in the child welfare system, this was another situation where the court engaged with the Parliament solution. In 2021, Parliament passed a specific Indigenous Child and Family Services Act, establishing national standards for the provision of child protection services to Indigenous children and families across the country, but also recognizing the inherent right of self-government of Indigenous peoples to develop their own laws, and in this regard, and also by establishing a framework for its exercise. The court, and Sébastien talked about this, the court upheld the constitutional validity of this law and provided important guidelines on its implementation, drawing on the concept of the honor of the Crown in this regard. It is too early to assess the full impact of the law, but I know that Indigenous governments are developing their own laws. This week I've counted there are 16 laws that have been in force. I believe these developments contribute to the growing recognition that solution to the systemic problems faced by Indigenous populations must be culturally appropriate and led by them. I'll mention more about this later on.
Question. What did the New Zealand Supreme Court do to address the impacts of the justice system in the Maori? And was this effective in changing the behavior of ground-level justice system actors?
Well, if you've got about a week, I can give you an answer. But first of all, kei aku rangatira tēnā koutou katoa. Ko tai mai nei au I te nukurua o te moana nui a kiwa ki konei ki kānata. Nō reira mihi ake ana ki te iwi nō rātau ngā ahi kā e tahu ana I runga I te mata o te whenua. Nō reira, taku ariki I shao. Aku rangatira tēnā koutou, tēnā koutou, tēnā koutou. I was raised always to formally greet your guests. So I have formally greeted you, my chiefs. I ask that you make me welcome here in your home, particularly to the Indigenous people whose fires of occupation and authority burn here still in this place. I've travelled the expanse of the great ocean of Kiwa to be with you, so I have jet lag. It's quite hard to translate jet lag into Māori. And I noticed that when I cracked that joke in Māori, none of you laughed, which indicated that you didn't understand what I was saying. Anyway, it's wonderful to be here and such an honour to be asked to speak to you. First of all, I think it's important to indicate that there is broad comparability between the circumstances of Indigenous people in this country and Indigenous people in my country. Even though the histories are somewhat different, we have the same sorts of asymmetries in offending and incarceration. So about 52-53% of the prison population is Māori. You're 6 times more likely to be incarcerated if you're a Māori. So you can see that we look to Canada to see what Canada is doing a lot in this area because the problems are very similar. One of the differences is that we do not have separate jurisdictional units that make the application of a tidy form of self-government particularly possible. Not impossible, but the circumstances in my country are such that expressions of self-government or autonomy tend to be much more organic and much more untidy. That has some advantages and some disadvantages. In my country, in a recent decision called Birkeland, we actually stole a number of ideas from your court. In fact, I do recall giving you several footnotes. We cited Gladue and Ipili in outlining how, during the process of colonisation, the stripping out of capital base and community autonomy had a direct impact on those whose capital bases were stripped and whose autonomy was taken away. So that but by the 1950s and 60s, following about a century and a little bit of colonisation, most Māori were poor, economic refugees in the urban areas because there was no land left, and perfect fodder for the criminal justice system. Same profile everywhere in the world where you see this phenomenon. So one of the points that Birkeland makes, following on from Gladue and Ipili, is to say that there is causative contribution between that story of capital stripping and autonomy suppression and current rates of over-incarceration and offending. The line is so common throughout not just the Anglo-colonial world, but throughout the entire colonial world, that the connection could be described as physics. It is simply not sensibly arguable that the two phenomena are not connected. So we pointed that out, relying to a great extent on the Canadian authorities that I've referred to. We have a section in our Sentencing Act, Section 27, which is a specific provision for what you would call Gladue reports. And it had been in the law since 1985 and almost never used, which taught me a little bit about the difference between formal law and the law's practical effect. That unless there is infrastructure underpinning the words on the page, even if expressed by our lawmaking bodies, are meaningless. So Section 27 got picked up really in the early 2000s by some more forward-looking judges, and we dealt with it in the Birkeland decision, which was 2021 or 2, I can't remember, something like that. But one of the things that we said, and I wanted to repeat here because of your mixed experience with Gladue reports that attempt to reset in Epili and the apparent failure of that reset, is that the report is not the point, which is what you were saying, Naiomi. What we see Section 27 as doing as providing a platform to draw the community into the sentencing process. That's its point. Now, if a community organisation, tribal or otherwise, it need not be Māori, if a community organisation from the community in which the offender resides, lives, comes, can be in the court to say to the judge, Judge, we know this person. He or she, usually he, is from our community. We have programs. We know this person's parents, family. We know that there are options here, practical options affecting this individual. Who is my nephew? Or my great-nephew? Or my neighbour? Then you remove the formalism of the punishment process and replace it with the communitarianism that Albie and Stephen were talking about in the process of rehabilitating and reintegrating offenders into the community. So the point of the report is not just to learn a little bit about the person, hopefully a lot about the person, but to co-opt that person's community into the process, to share power with that community. And by doing so, you achieve something judges and the criminal justice system simply cannot and never has been able to achieve, because of its, I always think of it as the state, certainly the criminal justice system, has the hands of a Tyrannosaurus Rex. They don't reach very far. But if you bring the community into the process, the reach is much deeper, and you are more likely to produce a positive result of, the no returns, which is what you want, if the community is engaged who know the person. The problem with state criminal justice systems is that they are so poorly integrated into the community, they have no idea which bits of the community and which resources in the community are going to be best deployed to assist this particular individual offender. So, actually none of this is new. The English did this for hundreds of years. In local county, I'm sure Lord Reid can tell you much more about this than me, but the village legal system had the advantage of the community owning the problem and being willing to share in its resolution. In the circumstances where we have seen that operate through Section 27 reporting processes, the results are spectacular. Not perfect, always an offender who just says, no, I'm going to keep offending, but in terms of the practical effect on individual offenders, your chances of solving the problem for that person, in our experience, seem to be increased markedly. So that's been an important learning in our process. The other thing I wanted to mention was, and this is not well known, at least not in my country, it may well be well known here, because I suspect the trend is the same. For a Māori man born in 1980, by the time that man is 35, I think, 10% of them will have been to jail. If you're born in 1980. This is the children of the generation that were the economic refugees. Actually perfectly predictable. But their sons and nephews are being incarcerated at 1/7 the rate of their fathers and uncles. 1/7. And not only that, the statisticians tell us that they are offending at 1/7 the rate. And this is not just for Indigenous people, this is actually a broad phenomenon in the Western world. It is extraordinary that this is not well understood. And I have found nothing, although I'm not a social scientist, so that may be my fault. I have found nothing that has attempted to explain that phenomenon. For Indigenous people, a fall of 6/7 is revolutionary. That's the rate in my country. I suspect it's probably of a similar dimension here, but probably not that well known. I also suspect that contributing reasons for that are the higher profile and more positive perspective on indigeneity and Indigenous culture in the wider community. The acceptance of Indigenous language education, of the place of Indigenous culture in the lives and cohesion of Indigenous communities, the celebration of Indigenous culture as part of the national narrative, the removal of the chip from the shoulder of the grandchildren and great-grandchildren of those whose capital was stripped and whose autonomy was suppressed, the removal or partial removal of that burden, I suspect, is producing these relatively spectacular yet unheralded results. If I'm right about that, then we may well be, accidentally, on the right track. Thank you.
Thank you. So now I'd like to move to the second team, which is can Apex Courts make space for Indigenous law? And when I'm speaking of Indigenous law here, I mean the law of Indigenous peoples themselves, like Cree law or Maori law, as opposed to state law that deals with Indigenous peoples, or what we in Canada call Aboriginal law. And I'd like to highlight that in this sense, Indigenous law is being taught now in law schools in Canada and New Zealand, and there's a growing demand for its recognition by the mainstream legal system. And when you think about it, Indigenous law in that sense is a manifestation of self-determination. So I'm curious about how does this play out in New Zealand? And I've heard about a case called Ellis. Could you just tell us?
Sometimes called by the detractors of the decision Alice in Wonderland. Can I, to make sense of it, can I give you some background?
Yes.
So there is a kind of a broad awareness of the challenge of recognising Maori custom, or the Maori legal order, as it's more commonly called these days. The word we use in my country is tikanga. Tikanga is the word for Maori law. Tika means correct, tikanga means the correct way of doing things. So in order to understand what I'm going to say in response to your question, I need to explain something about how tikanga works. The Maori system of law is a Polynesian system from the Eastern Pacific. So I have relations as far north as Hawaii, as far east as Rapa Nui, Easter Island, and as far south as my country. That big triangle is the Polynesian Triangle. All the peoples within that triangle share a core culture. I mean, they're very different, speak different languages, but the core oceanic culture is there across all of them. The key idea in that system of law is kinship. It's important to understand that fundamental difference. If, having gone through law school and gone to UBC, so I must know a little bit about law, and there've been a practitioner and a judge, I can tell you that the core concepts in the Anglo common law tradition are contract, freedom and autonomy of contract as between individuals, that my relationship with the planet is described by the term property, and that there is a central decision-making authority that administers my community, with which and among whom I am unrelated. In fact, if I was related to someone who exercised power over me in the system with which we are familiar, that would be a bad thing. Tikanga is not like that. The primary driver of relations between humans is kinship. So you have no freedom to enter into relationships. They are ascribed to you. So are your obligations. My relationship with the planet is not described in terms of property, but again in terms of kinship. I am related to the planet, and if we had 6 months, I could give you the genealogies. Those descent lines are well known and repeated. I descend from that mountain, I descend from that river, that tree and me are related by blah, 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 blah. You get the vibe. Turns out that my ancestors were right, because the scientists have said that 18% of the DNA of trees is shared by humans. So they are actually my uncles and aunts. And famously, one of the river tribes says, Ko te awa ko te awa ko. I am the river, and the river is me. It sounds nice and catchy in California, but to them that is a real statement of the legal position. They are related to the river as if it is family, which means the river owes them obligations, legal obligations, to sustain and maintain. And the people owe the river obligations, legal obligations, to protect and sustain and maintain, and amongst the humans, to be the voice of the river. So, this is a rather more holistic legal system whose core is the concept of the rights and obligations of kinship. All the Polynesian systems operate on some variant of that. Right, so in Peter Ellis's case, you've got to tell me to stop when we run out of time, because that lecture took a little longer than I intended. In Peter Ellis's case, this was a childcare sex abuse case. Peter Ellis was a childcare worker. The case arose in the early 1990s. It had been up and down the appeal chain twice, and he had failed. And except that on the second time up, he had not sought leave to appeal to the Privy Council, which would have been the jurisdiction in those days, because we didn't actually have a Supreme Court until 2004. So we just recently celebrated our 20th birthday, not long before you celebrated your 150th. I feel we've just got our diapers, really. But so he had one shot left, and in about 2018, 19, something like that, he sought leave to appeal to the Supreme Court. 20 odd years after his last attempt at review, and 30 odd years after the alleged events. He sought leave, and we granted it, having reviewed the evidence. We unanimously had some serious concerns about what had gone on. unfortunately, he had cancer, and he died before his appeal could be heard. There was then an application to continue despite his death with the appeal. We heard the application. During the course of the hearing over the posthumous continuation matter, a judge, not me, asked what tikanga would say about continuation posthumously. The parties during the luncheon break met and decided that this was an important question, all the parties, including the Crown and the interveners, and asked for an adjournment. We agreed to the adjournment, and they pulled together what they called a wānanga, which is a learned gathering of tikanga experts, of elders. This was held over 2 days at a marae, a traditional gathering house in Wellington. And what was produced from that was a statement of tikanga in respect to the case, about 3 pages, saying this is what tikanga would say about continuation. And they said that you should continue for the following reasons. Right. We had to decide whether the continuation would be allowed, and we relied on quite a significant Canadian case. Now I've forgotten its name. Marshall, is it? Anyway, there's a very good Canadian Supreme Court case on continuation, which we used, but the very important issue in the case was, should tikanga speak in this context? Now, in order for you to understand why this would appear to be somewhat remarkable, you need to understand that Peter Ellis was not Māori, nor were any of his victims. This was a question of how the common law in my country should develop on this very fundamental point of law. All of the parties, including the Crown, agreed that that was an important question to be resolved. All agreed that tikanga should have a voice in the development of principles in the common law on posthumous continuation of criminal appeals. So it ended up being relatively straightforward to write a decision that said clearly tikanga should speak because we are a common law jurisdiction in the Pacific, and we are not anchored just offshore from England or floating somewhere in the Atlantic between England and the United States. We have our own traditions, and our traditions are bijural. Bijural not in the sense of civil and common law, but in the sense of common law and the pre-existing tikanga order, the pre-existing kinship-based order. A great line the Chief Justice used was that thinking about tikanga when thinking about these fundamental issues for the courts provides a fresh vocabulary for addressing the same issues. And that really resonated for me because as I went through the considerations, including what tikanga would say about posthumous continuation, it occurred to me that that tikanga and the common law took very similar views for very similar reasons. And the new vocabulary provided a certain clarity, I'll give it to you now, a certain clarity to assessment of the law in context, which we felt was invaluable. Anyway, we agreed that the case should continue, and the appeal succeeded by a majority. We agreed that, unanimously, we agreed that tikanga is relevant to the decision. So I invite you to take a look at the decision. It's interesting for a number of reasons, but I'd better give Naiomi a chance to have her say.
Yes, and in fact, have the courts in Canada gone as far as Ellis, and if not, why, and should they try to do so, or could they try to do so?
Thank you. Not yet, that's the short answer, but there is some movement on this front. We could go back quite a ways. There's a very interesting case from 1867 called Connolly and Woolridge, which recognized the validity of a Cree marriage in a Montreal case involving estate succession. But after that kind of hopeful beginning, we had various other cases that for a long period of our history denied Indigenous jurisdiction and Indigenous laws for the most part. But I don't have time to cover all of that history. But I will, I will pick us up in 1982 and beyond, sort of talking about some of the early Section 35 cases, where the court has recognized that Indigenous peoples indeed do possess legal traditions and have said in those cases that they can inform the Aboriginal perspective on Aboriginal rights and title, as well as informing the common intention of the parties to treaties. That said, past engagement with Indigenous law via the Aboriginal perspective has been fairly limited. However, in the recent Restool decision from last year, the court engaged significantly with Anishinaabe legal principles, not only to interpret the common intention of the parties to a treaty, but also to inform the application of the honor of the Crown in that case, as well as remedies. Another case from last year, the reference on the federal act regarding Indigenous child welfare, the court endorsed a metaphor for reconciliation as being about the braiding together of Canadian, international, and Indigenous law. And these go further than we have been to date, but there is still a way to go. To answer the sort of second part of your question, Sébastien, I do believe that the courts could and should be engaging with Indigenous laws and jurisdiction more robustly, though I think our approach needs to be a hybrid between the approach that is happening in New Zealand and I would say the recognition of tribal self-government in the United States. And to explain a bit, as far as I understand it, the approach in New Zealand foresees a lot of the engagement with Indigenous law as happening primarily within the state courts. And I think I go back to your comment about, not having sort of the political units that we have in Canada with First Nations communities and such. So it creates a different picture. But I think as part of that, and this is what we see in the United States, Indigenous people need space for their own institutions and to be able to interpret their own laws. And in the US, there is a long history of recognition of the internal self-government powers of tribes. And over the years, tribes have developed their own court systems, and they hear both matters in civil and criminal law. And I think, UNDRIP gives us, the United Declaration on the Rights of Indigenous Peoples, gives us helpful guidance around sort of drawing distinctions between what I would refer to as internal matters to an Indigenous nation and what I will call intersocietal disputes, which are matters between Indigenous peoples and governments or third parties. And there is a support for sort of this distinction and allowing space for the internal matters to be heard within institutions belonging specifically to the Indigenous peoples and state courts hearing intersocietal disputes. Now, they're not watertight compartments. There's gray area in between, but it's a helpful distinction or categories, I think, that help us move forward. And I think having a body of law developed with an Indigenous group's internal institutions at the same time as having state courts engage with them will, I think, avoid some of the concerns that some scholars have written about simply having state courts engage with Indigenous law, possibilities of perhaps misinterpretation or distortion. And so, that's been one of the concerns about only exclusively having state courts engage with Indigenous laws. So what I hopefully envision is that a body of robust laws will start to develop within the internal institutions of Indigenous nations that can then be drawn on and inform the interpretation of Indigenous laws within state courts. And so the two are feeding on each other or informing each other in helpful ways. Now, we're still a bit of a ways away from this vision. There remains some reluctance to engage with Indigenous self-government as such, and its status under Section 35 still remains uncertain. In many ways, we remain in the shadow of a 1996 decision called Pamajuan, finding that self-government rights must be proven to be integral and distinctive to a pre-contact culture in order to be recognized. And it's been heavily criticized in the scholarship as being too narrow a test, specifically on government issues. And in the 30 years since the decision, no Indigenous group in Canada has succeeded in meeting the test. But things are evolving in some very interesting ways, including in several decisions from the court in 2024, and I think it will continue to evolve. The court has not yet returned to the issue of the status of self-government under Section 35, but it has confirmed that when governments purport to recognize or advance Indigenous self-government, in terms of their interactions with Indigenous groups, they are bound by the honor of the Crown to behave accordingly. It's sort of this idea. I've said it to my students as to walk the talk. If you're going to, act like it exists and, and say that to Indigenous peoples, then you've got to act like it. So I think that there's some really helpful jurisprudence that's being developed in that regard. And the case law leads me to think that we may be moving away from, I think, a previous preoccupation with having to prove certain self-government rights to accepting them as fundamental human rights and focusing on their implementation as more. So one way I put it is we're leaving the why behind and getting into the how. And I think the UN Declaration encourages this, and I think that's the way forward.
Oui, alors, tu parles de la déclaration.
You've mentioned the UNDRIP. I might jump a question I want to ask you. The UNDRIP, could it help Canada to motivate courts to move forward with this? I think the potential is huge. The Truth and Reconciliation Commission declared in its report, or they recommended in the report that the UNDRIP should be the reconciliation framework here in Canada. And after that recommendation, the federal government and provincial governments and territorial governments have adopted implementation laws. The court declared that one of the effects is to integrate UNDRIP in the positive law in Canada. And the Dixon case, the majority and dissident used that declaration to interpret Section 25 of the Charter. And all these developments indicate that the UNDRIP has a significant impact on Canadian law. And I agree with the Truth and Reconciliation Commission. The use of declaration is a guide. This will enable us to move towards a true reconciliation. We need to understand the history, the context of the declaration, because it gives us many principles we can focus on, especially when it comes to self-determination. One of the main motivations of the declaration was to propose an Indigenous specific approach to self-determination. And many sections of the declaration shed light on what this means. This declaration frames these rights as basic rights, amongst other basic rights that are recognized by the United Nations. I believe that lawyers have an important role to play in helping attorneys and courts better understand how the declaration could be interpreted in different contexts. And this is what I'm trying to do in my thesis with regard to self-government. There's still a lot of work that needs to be done with regard to land rights.
In New Zealand, is there potential for using UNDRIP to facilitate recognition of Indigenous law?
There's certainly that potential, but UNDRIP hasn't really captured the public imagination as much in my country as in Canada, and that's primarily probably because the focus, the site of debate is the Treaty of Waitangi, which is the original treaty entered into between the British Crown and 550 odd chiefs throughout the country in 1840. So, and the interesting thing about the Treaty of Waitangi is it's a framework treaty. It's not a land cession or a friendship treaty. So it's in 2 languages. The English language, the key articles, there are only 3 articles. The English language version says that sovereignty is given up to the Queen, Article 1. And Article 2, that's in exchange for her agreeing to protect the exclusive and undisturbed possession of Māori of their lands, forests, fisheries and such other properties as they may individually or collectively possess for as long as they wish to maintain the same. And then the 3rd article is a guarantee of equal rights, interestingly, in 1840. There are all the rights and privileges of British subjects, which is actually for its time rather radical. So that's the English text, nice and easy, written by lawyers, reads like it was written by lawyers, perfectly understandable to the common law, the common lawyer. The Māori text, sorry, we're getting off UNDRIP, but we need to understand why UNDRIP hasn't sort of caught fire in New Zealand. The Māori text doesn't say that. And that's the text all the judges, all the chiefs signed, and of course almost none of the chiefs could speak English. So in the Māori text, what's given up to the Crown is a thing called kawanatanga, which actually is a transliteration of kawana, you can kind of hear it, governor, tanga, which makes it governorship or the authority of governor. What's retained to the chiefs is not real estate rights, but te tino rangatiratanga o rātou whenua o rātou kāinga me o rātou taonga katoa. The tino rangatiratanga over their lands, their villages, and all their treasured possessions. Now, tino rangatiratanga means sovereignty. For example, in the Our Father, if you're Catholic, or the Lord's Prayer if you're Protestant, or if you're neither of those, then disregard what I'm going to say for the next 30 seconds. Thy kingdom come is rendered in the Māori kia tai mai tau rangatiratanga. So the kingdom of God is rangatiratanga. The scriptures were translated into Māori 20 years before the Treaty of Waitangi was signed. And most of the northern chiefs understood the basic ideas of the scriptures by then. So, in the Māori text, self-government is actually guaranteed in Article 2. And in Article 3, again, equal rights. So you have this tension between the 2 texts, which appears to make the whole thing look fraudulent. But it doesn't really, because what it shows is the precise debates about resource rights, land rights and so on, and rights of self-government and autonomy, which are the subject of debate here in this country, are played out in my country, albeit off the document of the Treaty of Waitangi rather than UNDRIP, Section 35 of the Charter and so forth. So, and the other thing I would add is that what drives the debate around autonomy and so on is a little more organic in my country because we have no constitution. We have no Section 35. The Treaty of Waitangi has, shall we say, an ambiguous legal status. It is not directly enforceable. The authorities have said that for 150 years. But it is incredibly important politically and morally. of course. So we've had a process of settling historical claims in which the tribes have kind of, you might say, been retooled through the process of settling claims over their historical losses with the Crown. That process of revitalization of the tribes, despite them not having reserves or separate jurisdictional units anymore, the revitalization of the Maori language, so that now there are many hundreds of thousands of Maori speakers in my country, including about 100,000 Maori speakers who are not Maori. There is a certain, the environment is conducive to these kinds of discussions, not because there is a top-down law that says it, but because there is a bottom-up organic reality that drives it. And that, I suspect, is a little different to Canada. It's unpredictable and occasionally a little anarchic, but it is quite authentic, and that's important.
Okay. Perhaps, in the interest of time, let me move to the third theme. And in the limited time we have, obviously we cannot engage in a detailed comparison of what apex courts have done with respect to issues that we mentioned, land rights, treaty rights, consultation, and so on. But I think it raises the more general issue of the proper role of apex courts in making the law evolve. And this is particularly obvious in Indigenous law cases, where I would say courts have sometimes taken bold steps. I'm thinking of cases such as Calder or Haida Nation. But you know, other branches of government may have their own views as to the proper scope of Indigenous rights. And here in Canada, we have the famous metaphor of the dialogue. I think Peter Hogg was mentioned earlier today, a dialogue between the Supreme Court and Parliament with respect to the scope of charter rights. So my question is, has there been a dialogue, and perhaps we can start with New Zealand, between your apex court and the executive in the process of building an Indigenous law jurisprudence?
Well, once again, our constitution might be best described as somewhat untidy and organic, so that dialogue is what dialogue does. There is a lack of formalism, but there is dialogue, and it is usually extraordinarily important. And just a few months ago, there was an example of just this dialogue. And let me just, in 2 minutes, summarize it. And then
you have to. Yeah.
There was a claim over rights to Indigenous rights to the foreshore and seabed, in the context of legislation that had been enacted following great political controversy called the Marine and Coastal Areas Act, which provided quite a stiff kind of test for the acquisition of customary title or native title or Aboriginal title to areas of the foreshore and seabed. Incidentally, the legislation borrowed heavily from Dalgamuk. The Court of Appeal interpreted the legislation in a way that rather surprised the executive and the legislature. And the executive planned to introduce into the House a bill to overturn that decision of the Court of Appeal. Before that could happen, there was an appeal to our court and we granted leave. We had a hearing in November. The proposal was that the bill would be introduced into the House in December. So you can see this is potential constitutional chicken. We felt nonetheless that it was important to give the parties and the legislature the benefit of our own view of what that statute was intended to mean in practice. Not because we were incensed that the legislature was overturning a decision of a court below us, but because of this idea of dialogue. The idea that the forensic process can produce potentially clarifications that the legislative process is not well designed to produce, and that if that's fed into the process, it can assist the development of the legislation. And that's what we did. We issued the first part of our judgment 2 weeks after the hearing, quite a substantial judgment, probably around 80, 90 pages. And there were those who criticised the court for interfering in the legislative process. But there were also those, including those inside the system, who found the judgment helpful. Not just as a sort of freewheeling opinion as to what the nature of Indigenous rights in the foreshore and seabed are and what the legislation was supposed to do in respect of them, but a view expressed with respect to particular facts in a particular controversy in which the workability of the legislation and its practical application could be the matter of forensic analysis and judicial comment to assist the legislators. That process is continuing, so I can't tell you how it will end, but I can say that the bill did not get introduced into the House, and there is now a careful assessment being undertaken by the executive's advisors as to what should be done now. And that seems to me and to my colleagues to be a very healthy way of ensuring that the laws we produce, whether they are judge-made or legislative, are of the best quality in one of the most controversial areas of law in our country. So my hope is that good will come of it, whatever the final legislation looks like.
Okay. And are there any examples of dialogue in Canada with respect to the building of an Indigenous law jurisprudence?
Yeah, I think I'm going to pick up on a few different points and I have a few disparate thoughts in response to this one. And because we had to skip some questions, I'll try to weave in some key points that I wanted to put out there. I think one of the first things that I wanted to do was, particularly to a couple of Joe's points, a lot of the places where Indigenous people have gotten today with Canadian law has been by so many acts of resistance and pushing, and so nothing was ever sort of given freely, but rather so many things were the effort of Indigenous people's resistance and pushing. So we've had our messy bits, and that has informed, I think, a lot of where we are. I think so. I'll come back to that thread in a sec. The other point that I just wanted to make is one of the points I had intended to answer, and I really want to get it out and weave it in here, is the issue of Indigenous laws and culturally appropriate and Indigenous-led laws is so much about legitimacy, right, and having legitimate sources of order for Indigenous peoples. But there's also a legitimacy issue for the Canadian state, right? And the fact that we are in a country on lands where it was the people who were here before, and so a legal system for a long time that denied the land rights and the self-determination rights of Indigenous. So the project for Canada too is about legitimacy and doing this work. So I mean that informs a lot of, I think, the project of when we're talking about Section 35. And it's challenging because even how Section 35 came to be in the Constitution Act 1982, that was a struggle. And I don't have enough time to get into it, but it was a hard-won struggle. Indigenous people went to the UK to ask the English Court of Appeal to prevent patriation, and so it was so much of a struggle and very political. And what got eventually put into Section 35 was a very broad statement, right? Which the rights, Aboriginal and treaty rights of the Aboriginal peoples of Canada, existing rights are hereby recognized and affirmed. And people have asked, what's in the box, right? And so they've kind of sometimes talked about 35 as being this empty box. And the promise was that there was going to be further constitutional conferences where this was going to be fleshed out. But of course, that didn't happen. And I think the lack of political will, or they happened and they failed, I should say, there's a longer history. But ultimately it fell to the courts, in this particular court, to set out and try to, I think with that idea of Canada's legitimacy in mind, trying to set out frameworks to sort of move us forward. And I have been certainly critical of some of the judgments of the court, but in some ways operating without a lot of guidance. They could look to some decisions from the US or Australia or New Zealand, but that sort of challenge. And so it's interesting because you think about dialogue often as being about legislative actions taken by the courts, legislative actions taken by Parliament and legislatures, but it's been a bit of a vacuum in Canada. And there was even, I think, in the DeSoto case from 2021 or 2020, where the courts say, no, a lot of this has kind of fallen on us. Now, we're seeing a bit of a change now, I think, with the UN Declaration and the implementation legislation, where that is providing impetus for governments to be taking more action. There were some, but it was primarily very piecemeal for a period. And I think the UN Declaration is also providing a helpful, not just a guide for governments, but also courts as well as an interpretive guide. So I think that's helpful. And it's, the fact that there is implementation legislation also sort of adds to the idea that this is indeed a dialogue. On the dialogue point, though, I wanted to bring back a quote from Mark Walters, or I'll just kind of explain the idea, but he says in this particular context, it is far more than just a dialogue between the courts and legislatures. It's a huge dialogue that includes Indigenous peoples, their treaties, international sources, scholars, and so he says one thing that should be clear is that the law that the judges are trying to identify and expound is not of their own making. They are merely participants in a process of interpretation that seeks to give shape and texture to an unwritten constitutional law of intercultural relations in Canada. Judges play a critical role in that process, but there are other participants too. And in the end, judicial contributions only serve to inform, not determine, our understanding of the law itself. And I think that complexity really shows in Canada, but I think it leads to a richer jurisprudence.
Thank you. The reality is that we had prepared a little bit more, but I want to, there are very good questions that have been asked. I suspect that some of them have been partially answered by what the panelists have said, but there's this one that I want to ask. Do Indigenous judges on apex courts make a difference? And did it make a difference in Ellis? But perhaps I'd like Naiomi to start answering the first bit, and then the second part. And
then we'll be out of time.
Okay.
I will keep it short. I think representation does make a difference, and it does in a variety of different ways. It can take more explicit, but I think it also can take more subtle and nuanced forms. And I can't speak, I can speak from my own experiences on being on various boards within the legal profession, and at a point I was on our legal regulator. But being in the room, being there, I mean, not that people are, necessarily trying to ignore your issues, but being there, I think just, and being part of the conversation just really, I think, helps situate your colleagues and those around you, understand, providing context, but also even presence as well, but also knowledge will help in having, I think, richer dialogues with groups of people. Mm-hmm. That's all I'm going to say.
I just wanted to say I'm wearing a Canadian Supreme Court tie. We don't have these in New Zealand. We're a poor apex court, but I'm going to get our Chief Justice to have some New Zealand Supreme Court ties, and I'll send you all one. I think my answer is yes and no. It's useful to have an Indigenous judge on an apex court because it civilizes the discussion, ironically. You avoid, there's less opportunity for the casual, unintended racism of your colleagues, just as a couple of decades earlier there would have been less opportunity for the casual, unintentional sexism of male judges. That's fine. But what I think I can bring to the court is a knowledge and experience of growing up in a Maori community and knowing something about Maori law and Maori custom and Maori language, so forth. That means that I try to encourage the development of a law that is respectful of those things. So that's not really rocket science. I'm not going to turn the system upside down because I bring those skills, but it reminds me that that presence needs to be in every room, across the judiciary, in fact, across the legislative spheres and the executive spheres as well. And that seems to be the project. And frankly, you don't have to be Maori. If you get it, if you get tikanga Maori, I don't care what ethnicity you are. What's important is that you bring to the discussion a respect for my legal tradition and my experience. We have just developed a postgraduate diploma in tikanga and law for judges in partnership with one of the Maori tertiary institutes, Maori universities, you'd call it loosely in English. The first cohort has gone through 16 judges, less than half of them Maori, from all of the courts, from one Supreme Court judge to Environment Court, District Court, Family Court, so forth. And I can tell you it has been an outstanding and stunning success for all judges, those who are Maori and familiar with tikanga, and for those who are not Maori and unfamiliar with tikanga. And what they say is, all of them, that the process has been transformative. And what it has taught them all is what I call the cognitive shift. The development of intuitions, which we are all taught through law school and so on about contract and public law and property, intuitions we don't even notice we have anymore. You can then have intuitions that relate to kinship and place and community. Once you develop those intuitions, it doesn't matter what your ethnicity is. You're going to incorporate those things into your judicial life, into your life in the law. And the law will develop in ways that are respectful of that separate source of law and tradition, but in ways that assist in making it continually relevant in the 21st century. That balance between respecting that this is not yours, but struggling to maintain or develop its relevance and importance in modern life seems to me one of the great challenges of the development of the common law generally in our post-colonial countries, both yours and mine. So let's get on and do it.
Could I just jump in?
Oh, yeah, you can.
Just because I know there's not a lot of time, but I just want to say on to that,
Trap
for those
is about to open.
who are listening, you know, in New Zealand, there's the Maori culture, and some of you might be thinking, well, that's great for Maori. It's one nation, right? And in Canada, we have so many. But I do want to, and I didn't get a chance to say, that there is such wonderful work now happening throughout Canada, different institutions with different universities with different communities about drawing out Indigenous law. And what you say as intuitions is really drawing out the worldviews, the values, the principles that underlie how Indigenous people see the world. And people are developing similar courses about learning about, Mi'kmaq law and Cree law. So I want to say that kind of work is happening here as well.
Including the National Judicial Institute.
There you go.
Can I just, we always finish with a song, and Naiomi told me that we should encourage Canadians to start doing this. So, and because Albie and Stephen were so good, I said to Albie I needed to punch him because it was such a hard act to follow. I thought I would distinguish our group from the next group by singing a song. This is no, well, don't clap until you've heard how badly. This is a song that talks about survival and struggle. Tiro tiro kau au ki marae, kai ngā hera, kei hea koutou e ngalo nei, e te iwi era. Taku aloha ki ngā tai, e ngunguru e ri te mai ki te iwi e ngunguru noa nei alai. Thank you very much.
Beautiful. Wow. Beautiful.
Well, thank you, Justice Grammond, Professor Metallic, Justice Williams, for that amazing, fascinating, unique presentation on a subject that I think we all know goes to the roots and identity of a country, offering real opportunities for reconciliation and a better, fair, respectful society. So thank you for setting the stage for some of those challenges and opportunities ahead.